Intellectual property basically refers to property that you have come up with from something from your mind. You create it with your mind. The way you have your car, you have your house, you have other properties, your phone, your watch. Intellectual property is property, but that is created by your mind.
There are various types of intellectual property. There are two main branches actually. There is the branch that is known as industrial property, and there's the other branch that is known as copyright. So industrial property refers to intellectual property in the form of patents, which basically protects technological inventions, scientific inventions, and other kinds of inventions. And then trademarks protects names of organizations, of businesses. Basically, trademarks protect the commercial origin of a product. That means that when you hear about a trademark, then you associate that product with a certain entity or with a certain group. For example, an example of a trademark is, for example, Vaseline. So when you hear of Vaseline, you know it is a product like a petroleum jelly or that kind of thing. And then the other branch of the other type of industrial property is the industrial design. And industrial designs, basically, they protect the look and feel of products. So you may have something like this watch that I'm wearing. It has a particular look, a particular design. So that design is protected by industrial property.
Copyright is part of intellectual property. It is the legal rules that protect your creativity. But this only refers to works in the artistic realm. You have works in the musical realm, literary, artistic works, even software. They are created, they are protected by copyright.
Those rights include, for example, the right of reproduction. This means that the copyright holder is the only person who has the right to make copies or to reproduce their work. For example, if it's a book, they're the only ones who can make copies of that book. And then the other one is the right of fixation. This means making it into a tangible format. So it is only the copyright holder who can, have that copyright work fixed in a tangible format. For example, recording it. The original recording can only be done by the copyright holder. Like now, if it's a song that the copyright holder wants to record, that initial recording is what is known as fixation, and they're the ones who have that right. The other right is the right of distribution. Distribution simply refers to the distribution, like the physical copies of the work. For example, if it's a movie that is in form of a DVD, so the physical distribution in form of sales, rental, and leases, but it has to be a physical kind of distribution. The other one is the right to public performance. That means that as a copyright holder, you have the right to publicly perform your work. For example, as a singer or as a performer, you have the right to go on stage and sing and perform publicly so that people can see you and people can hear you. Those are some of the rights. And then when we talk of literary and artistic works, it is not just limited to literary and artistic works. There are many other categories of works that can be protected. And this include, when we talk of literary works, we talk of works that are written down, for example, books, computer software, movies, and all that. Then we talk of musical work. These are the works, for example, the musical notes, the musical notations that compose the musical compositions, basically. And then when we talk about sound recordings, this basically, as the term is, it just refers to the recording of the musical works. It may be not necessarily a musical work, it could even be a spoken word, but it's as long as it's recorded, then that is it is referred to as a sound recording. And then the other ones are artistic works. These include works such as paintings, carvings, and other forms of sculpture, as well as drawings and illustrations, even maps and sketches, those kinds of things. And then when we talk about broadcasts are also a form of copyright works, and the other one is audiovisual works. Audiovisual works refer to, films, movies, those ones that can be seen and heard at the same time. So those are the major categories of copyright works that we have.
When someone talks about copyright protection, what do they mean? Generally, it just means that the law has given you some right, yeah? And what right is that the law gives you? The right the law gives you is there are two kinds of rights. You have economic rights that the law gives you. Basically, the law is saying if you're the artist, if you're the creator of this thing, then you have the right to control how that thing is used, where it is used, and by who. And that right, you could give it out for free or people could pay for it. So copyright gives you economic rights. Economic right means you have the right to control distribution of your work. If I have music CDs, the distribution of that work should be in my control. Copyright also gives you right of reproduction. If I have music CDs or books and somebody wants to reproduce many copies of it, they would need to ask for my permission. The other right that copyright gives you, which is economic, it is called communication to the public. If you have a song, for example, and I take it to a TV or radio station, I need to ask for your permission or pay for that. The other right that copyright gives you is public performance. If, for example, I call a crusade and I want to sing somebody's songs, then I will need to ask for their permission or pay for a license. Again, if you want to use somebody's work in terms of sell it, hire it, loan it, adapt it, translate it, or even import it, then that right is reserved for the copyright owner. Now, the other right I said is called moral right. Basically, moral right is the right for you to claim ownership to something. So that if I have taken a photograph, I have a right to claim ownership to it. If I've written a book, I have a right to claim ownership to it. Moral right also allows me to object from my work being used in a manner I don't want. If, for example, I'm a gospel artist and I've sung a song, I have a right to object that it cannot be used in a pornographic movie. The other moral right that copyright gives me is called the right to anonymity or pseudonymity. What does that mean? That means that, for example, if I want to write a book anonymously because maybe of the sensitive material in the book, then I have a right to do that. I can publish anonymously or use a pseudonym. For example, in Europe, a long time ago, women were not allowed to publish. And so you found that women would publish under male names. If you have read the book Karen Blixen, Out of Africa by Karen Blixen, she initially used to write under a male name because women were not allowed to publish and to write. So the moral right copyright gives you also is to use a pseudonym. For the musicians and artists who have what they call stage names, that can be your pseudonym, and you're allowed even to publish your works and produce your works under that pseudonym or stage name.
So there are also issues about when copyright works can be used without the authorization of the author or the owner, because as I said, the copyright, the rights that I talked about, the right of distribution, the right of reproduction, and all those other rights, they belong to the author. But then there are instances when a third party can do any of those uses without getting the permission of the author. And this is what are usually known as the exceptions and limitations. So there are some instances when the law allows this. And for example, one of the reasons is, for educational purposes, whereby you have to maybe record a video from maybe a broadcast so that you can, as a teacher, you can, teach it to your learners in class. So that one is one of the exceptions, for educational purposes. Another exception could be when you want to quote. Maybe you are just having a thesis, you are writing your research, and you need to quote a previous author, so you can quote them for that purpose. Another exception is also when you're talking about what is known as parodies or pastiche, whereby you kind of make fun of a previously produced work or a previous copyright work. So some of those uses do not require the permission of the author. But then it is important to know that if you're doing that, you just need to acknowledge who the author is clearly and expressly, so that people or outsiders or third parties do not think that you are the copyright holder.
Now, the other benefit you can get from your copyrighted work is by doing registration. What is registration? Basically, registration is just going to register your work and get a certificate for it. What are the benefits? One is that it is easy to prove ownership once you have done registration. Whenever a dispute arises, it will be very easy for you to give out your copyright certificate and prove ownership. But also in developed nations, people use copyright certificates as collateral to get loans from banks. If, for example, John Grisham went to a bank to get a loan, you bet he would be given, because he's a big publisher and they know that out of his copyright, he's able to earn enough money. So in developed nations, copyright registration helps you to get a certificate which you can use as collateral to get a facility like a loan. Now, copyright does not protect ideas merely. It protects your expression of that idea. If I have an idea of a love story, the idea must move from my head into a writing and eventually into a book or a journal or an article. This is called the idea expression dichotomy. Copyright does not protect mere ideas, but it protects expressions of those ideas.